Okay, we're here tonight, Wednesday, November 20th, for the Community Police Review Board meeting. It's 5:30. I'm going to call the meeting to order. Remember, we're up and running with the technology, so when you want to speak, just push the request to speak button, and then we'll call you in order. And if you make a mistake on this at this point in the game, you're still going to be okay. Okay, can the clerk call the roll?
Member Beasley Day. Member Bryant. Member Byrd.
Present.
Member Christensen.
Here.
Member Demrell.
Here.
Member Grant. Member Smith. Member Solorio.
Here.
Chairman Hahn.
Here. Okay. Anybody have a declaration of conflict of interest if anything's on the agenda? Seeing none, we'll move on to public comments. If you'd like to come forward and state your name and give your comment, you have 3 minutes. Okay, seeing none, we'll go on to consent calendar. Consent calendar is consider approving the minutes from our last meeting. Does anybody like to have any comments about that? Any corrections? If not, I need a motion.
I'll second.
Okay, all those in favor say aye.
Aye.
Opposed? There's no new business. Staff comments and reports. Independent police auditor report.
Good evening. I'm here, Chair Hahn. I hope everybody can hear me okay.
Yes.
Thank you for accommodating me remotely, and I look forward to being there in person for the last meeting of the year next month. That trip to Modesto will also be my opportunity to meet with the police folks and start putting together sort of the random sampling of completed cases in the misconduct investigation and use of force tracking system. So it would be my second full year of auditing the department's internal investigations and publicly reporting out on the effectiveness of those investigations and recommendations. So it's hard to believe another cycle is almost complete, but I will look forward to being up there, visiting with the department, getting that list of materials together, and then attending your meeting in person. So I will look forward to seeing everybody then.
Anyone have any comments, questions? Steve? Anybody from the audience? Okay, seeing none, we'll go on to the revisiting the workshop on collective bargaining.
Excuse me.
Good evening, board members. Christine Alger, the Director of Human Resources, and I'm going to be presenting to you tonight on the collective bargaining process. If the slide moves. All right, so a quick agenda of what I'm going to go over tonight. We're going to cover the governing entities. And so those are the entities that govern the process. We're going to go over the legal requirements that are required by both parties, the MOU requirements of collective bargaining, the actual bargaining process itself, and the impasse procedures and what those look like. So first of all, the collective bargaining, the legal landscape. And you may have seen these slides before. So I was here many months ago giving another presentation on the arbitration process. And so some of the slides were in that presentation as well. So some of these may look familiar to you. So MMBA, or Myers-Millis-Brown Act, hard to say, was established in 1968, and that's actually in the government code. And what it does is it oversees government entities when it comes to collective bargaining. So it provides the requirements to meet and confer in good faith, and it's over California's municipal, county, and local special district employers and employees. And so during 2001, it actually went under the California Public Employment Relations Board, or PERB for short. That is the governing body that oversees this process for us. And so PERB's jurisdiction actually excludes peace officers and management employees, but covers everyone else. So just a little bit on PERB. So PERB is under California Government Code 3541. It's governor appointed, 5 members. They're responsible for administering the statutes under the code. And so they hold elections to garner interest in unionization. They prevent and remedy unfair labor practices. And we'll talk a little bit later about what unfair labor practices are. They bring court actions to enforce PERB decisions and rulings, and other actions to fulfill the purpose of the act. So unions or employers may file unfair labor practices to PERB when they see the need. And they also provide for the state mediation and conciliation services, and that's where we get arbitrators. So I do have the National Labor Relations Board in here. This is a new slide from last time. I refer to this because PERB sometimes looks to the NLRB for their decisions and their guidance. And so they'll look at some of the decisions they made when they're trying to determine a decision on their own. So they're a federal agency. They really oversee private entities when it comes to unionization. They're president appointed, 5 members, and responsible again for administering the statutes under the federal law. And then we have the city charter. And so in the city charter, Article 7 of the Personnel System, Section 1206, impartial arbitration for police and fire department employees' disputes. And so this section is quite expansive. So I've just brought in a few little pieces of that. If you're interested, you can read the full section online. But basically, because public safety is a detriment to the community, there's a prohibition to strike. So they're not allowed to strike as normal unions would. And so they're declared a policy that police and fire striking is not in public interest. And so alternative dispute resolution methods are required. They're also required to meet in good faith. And so no existing benefits or conditions of employment shall be eliminated or changed without meeting in good faith. And then they have impasse procedures that are included in the charter. And so all disputes or controversies remaining unresolved after good faith bargaining shall be submitted to a 3-member board of arbitrators. And I'll talk a little bit more in detail later about what that looks like, how that's formed. And then so it also shall conform with Title IX of Part 3 of the California Code of Civil Procedure, which outlines all of the procedures that have to happen in an arbitration. So MOU and collective bargaining process. So the MOU also requires that we meet in good faith, and also under Section 3504. So this is in our MOU. The scope of representation shall include all matters related to employment conditions, employer-employee relations, including but not limited to wages, hours, other terms and conditions of employment. And so that includes, all of the policies and procedures that we put in place as well. Our contract, as you know, for the police department expires June of 2027. We have a new union contract in place right now. And in between, negotiations. Sometimes we do some side letters for operational needs. So types of bargaining. So there are two basic types of bargaining that can happen in the room. And so the first one, the traditional bargaining, it's also called positional bargaining. So you'll hear that term sometimes. But really when we do traditional bargaining, you know, one party will take the first step to put a proposal together. They'll present that proposal to the other side. The other side will then have some time to look at the proposal, and then they do a counter proposal. And so each time the parties meet, the proposals are passed back and forth. And the idea here is that the parties hopefully are continuing to close the gap between, you know, where each party started, and that at some point we come together on an agreement. The other way of doing bargaining is called interest-based bargaining. And so with interest-based bargaining, you don't come in with, you know, wanting certain things. You come in with your interests. And so the way that process works is it's typically facilitated by an outside entity. It's not an attorney, but they're just facilitating the conversation. And what they do is they ask each party to kind of list concerns. What are you concerned about? Are you concerned about, you know, the economics? Are you concerned about, you know, being able to fill your vacancies? What are your concerns? And so each party puts their concerns up on the board, and then together we determine in what order we're going to address those concerns. And so the idea is to talk about the concerns. Why is it a concern? And what are some ideas that we can address the concern? And so it's a little bit different from positional, where you just come in with an idea. This one, you kind of work together to determine what are those things that we can do to address that concern. So the collective bargaining timeline. So this is typically the process of collective bargaining. So when we initiate the process, either one party or the other will approach, and we'll, you know, make the intent that we want to begin bargaining. And so once one party addresses the other party and says, we would like to start the bargaining process, we'll, you know, talk about things like proposed dates. We usually typically start the process of bargaining about 5 or 6 months prior to the contract ending, to give us enough time to be able to meet and, you know, and ensure that we've had time to discuss all of the items. And so once we've done that initial process, we go in meeting one. When we first meet, there's typically some things that we generally do every time. So one is, you know, establish what type of bargaining process we want. So do we want to do the interest-based bargaining, or do we want to do the more traditional type of bargaining? What is that going to look like? So we kind of agree on what that's going to look like. We also talk about the rules of engagement, such as communication expectations. And so, you know, I do have a little footnote in here for that. It includes, you know, who will be involved on both sides of the room. It'll include also like, who are we going to agree to talk to outside of the room. And so for instance, on the city side, as the chief negotiator, I would probably let them know that I would be talking to the city manager. I'm going to be talking to council because council gives us that authority. And so it's agreed who's going to be communicated with on both sides. And then also we talk about things like confidentiality, and we have a confidentiality agreement that, you know, whatever we talk about at the table stays at the table, and that we only agree to talk to those parties that we've discussed that we're going to be sharing information with. And then we also talk about goals. What are our goals? When do we want to have something hopefully done? What is that going to look like? And then our successive meetings, we just, you know, create that schedule and we continue to meet. Usually, in my experience, we typically would meet like every 2 weeks. And so we just do recurring meetings and continue through the process. And hopefully, as we move through the process, we come closer together to an agreement. If such agreement doesn't happen, if we've done all these successive meetings, we've met in good faith, then you can declare an impasse at that point. And I'll kind of talk about what an impasse is and what that procedure looks like. So just a little bit about preparing for bargaining. And so both sides obviously will do some preparation before we start bargaining and as we move through the bargaining process. Obviously, we're going to review the MOU on our side, and we're going to look at potential challenging language. So maybe something is hard to implement because of the way it's written. We also look at operational concerns. We're also going to look at things like, what are the city's goals? Do we need to do something to help with recruitment and retention? So we look at all of those things on our side. We also try to anticipate maybe what the union requests might be. But a lot of times we don't really know until we get into the room and we start discussing things back and forth. We also typically look at salary and benefit study. And so we'll go and we have 9 comparable agencies that we typically look at. And so we'll go out and gather that information to kind of see where we're at in the market. And that will be a consideration on the city side as well. And then we also cost other potential items that we may want to look at. On the union side, a lot of times what they will do is they will survey their membership to try to determine like what is their membership, what's most important to them, what would they like to see them bring to the table. They also do their MOU review. And sometimes even the union will go ahead and do their own salary and benefit study and bring that data with them as well. So the council's role. So a council authorizes all potential economic items. And so anything that has to do with wages, incentives, benefits, and other major impacts, the council they are the authority. They are the governing body that directs us as a city through the negotiations process. And so they approve whatever it is that we're able to offer. As a chief negotiator, myself and the city manager will meet regularly with the council, provide them with updates, let them know how things are going, receive further direction based off of how things are progressing. So the tentative agreement and MOU process. And so typically at the end of negotiations, hopefully if we've come to an agreement, we have what we call a tentative agreement. And so it's tentative because both parties at the table have agreed to that, but it still has to be ratified by the union side. So they have to go out to a vote of their membership and ratify whatever agreement the union representatives have agreed to do with the city. And then for the city side, we have to bring it to an open session council meeting and have it adopted. And so tentative agreements are typically, the economic items and some operational items. And so wages, incentives, those types of things. And then another process that we do during the MOU process is language cleanup. And so we typically will look at old language, trying to get, old language out that's not relevant anymore. Looking at, updating scheduling language if schedules have changed and things like that. So the impasse procedure. So the charter has an impasse procedure for police and fire because again, they don't have the right to strike. And so this is all outlined in the charter. And so either party can declare an impasse. When an impasse is declared by either side, then what happens is we have to put together an arbitration process. So each party must select one arbitrator within 3 days of notice. And so if one party notices the other party, they each have 3 days to choose an arbitrator. And so we would typically choose arbitrators that, typically do arbitration process. A lot of times attorneys are very well aware of different arbitrators that they may want to use because they've had, good success with them in the past. Unions may as well. So there may be some arbitrators that they have in mind. But if we don't have an arbitrator in mind, we can actually ask the state conciliation board for a list of arbitrators. And so
Can I ask
each
a question that I
yes,
think
go ahead.
when you say impasse, you're talking about one item in the whole or the whole contract? Is it at impasse?
That's a great question.
Because it's a much different thing, and everything you're talking about is it just by item or is it by the whole contract?
So that is a great question. It could be either. It could be a portion of an agreement that's not being agreed to. It could be the entire agreement. I'll tell you a lot of times what we do on the city side is we do package deals. And so when we put together a proposal, it's kind of like a package proposal. So we want the entire thing to pass through. Unions a lot of times will do the same thing on their side. And so a lot of times when we come to an impasse, it's because of there's something major in there that the parties just can't agree to. Or we're so far apart from each other on many items that we're just not making any progress. So typically what happens is, you continue to meet, and if you're just not making any headway, it's a stalemate basically, then, either party can declare an impasse at that point. So we agree that we agree that we don't agree. And so with that, we do a panel of arbitrators. So one arbitrator on each side, they get to pick, and then the third arbitrator has to be agreed upon by both parties. So each party gets to pick their own, and then together we have to agree on that third arbitrator that's going to be on that panel. And if parties can't agree, again, we can go to the State Mediation and Conciliation Board. We can request a list of arbitrators. And the way that process works is it's kind of like a strike process. So we each take turns striking names off until we land on whichever one we land on. Yes.
Isn't it generally that if it's just a single item, unless it's a definitive determinative item, don't the parties, aren't they usually required to negotiate, continue to negotiate in hopes that as they negotiate, things will fall into place, so they continue to negotiate for the whole contract before impasse?
Yes, so we do try our best to continue to negotiate as much as possible. The idea is to eventually come to an agreement. And so you exhaust that before an impasse can be, because we have a duty, both sides have a duty to meet in good faith. And so part of meeting in good faith is exercising the due diligence and making sure that we've totally exhausted the process before we go to impasse. Any other questions before I move on?
I have a bunch of questions, but I'll hold until the end.
Okay, thank you. So hearings are conducted as outlined in Title IX of Section 3 of the California Code of Civil Procedure. And so again, that just outlines the process by which, everything has to be followed in that hearing. A written decision is delivered to both parties, and then both parties have 10 days to mediate further and agree. So what can happen is if we were to go to impasse and we get this written decision, it's delivered to both parties, and then we have 10 days to be able to still meet and hopefully further negotiate and maybe come to an agreement. If we can't do that, then the arbitration decision is final and binding. So there are impasse procedures also for non-public safety. And so I know this is more kind of geared towards the public safety, but just so that you understand the difference. This is also governed under MMBA. So again, the safety is police officers are not covered under MMBA, but the rest of the organization is. And so again, here, either party can declare an impasse if that's the case. But there is a fact-finding process that happens with the non-public safety groups. And so mediation is the first stop. And so you have 30 days for a facilitator to mediate an impasse. And this is actually voluntary. So it's not required by the process, but it is a typical part of the process. But again, it's voluntary. So not the parties don't have to agree to do the mediation. The employee association is the only one who can request a fact finding. So if, we declare impasse, either one of us can declare impasse, but only the association can request that fact-finding process. So within 5 days, each party chooses a representative, after which PRB, because PRB, again, oversees our non-public safety, they appoint the neutral. So that's not agreed upon by the two parties like you saw in the first example. This one actually PRB just appoints a neutral. So the panel meets with the parties, they gather evidence. It's kind of a little bit informal. They gather evidence and, testimony from both sides. Both sides submit what they think is relevant to their case. And then they do a recommendation, which is advisory of the terms of settlement. And so after that recommendation has been delivered to the parties, it becomes public 10 days after issuance. Now, with this process, an employer can implement its last, best, and final offer. So here, we're able to unilaterally, implement a last, best, and final offer. The rules are, though, that we must wait 10 days from the panel's written recommendation to be delivered. And then we must hold a public hearing regarding the impasse prior to implementation. So it would have to come to an open council meeting as a hearing. And that process has to go before the employer can unilaterally adopt their best, last, and final offer. So this last slide really talks about unfair labor practices. So just to give you an idea of what unfair labor practices are, and either side can bring a charge of unfair labor practice under PERB. So failure to bargain in good faith. So things that the employer can do that may be considered an unfair labor practice, stalling tactics. And so it's been seen in other places where, a party may, stall, they may, cancel meetings and say, we're not ready to meet. And so stalling tactics to kind of draw out the time is not allowed. Refusal to consider items. And so even if they bring forward an item that we don't think is an appropriate item for them to bring forward, we still have to do our due diligence. We still have to consider it. We still have to have those discussions with them and really, truly look at it. Pattern bargaining is another thing. So if you can't require two different unions to agree on the same thing. So, we'd like to have everything uniform, but we can't by law do that. Holding information. So if the union requests information from us, we have to turn that information over in a timely manner, and making unilateral changes. And so we're not allowed to do that without the bargaining process. On the union side, for unfair labor practices, illegal strikes obviously are part of that. Of course, our safety unit can't do that. Refusing to bargain, and so refusing to meet, refusing to discuss can be an unfair labor practice. Making unreasonable demands can also be considered an unfair labor practice. And so any ULP can be filed with PERB, and PERB will investigate and issue rulings on those items. And with that, I'd be happy to answer all your questions that I can.
You got to push the button. Did you push the
I tried to,
button?
I don't know what's happening here.
Okay. You go ahead. I just
Okay.
wanted to pick on you.
So if the Public Employee Relations Board has no jurisdiction over peace officers, is there any governing body that does?
So ours is governed by our charter. And so,
there's no state agency or federal agency.
no.
Next question. You mentioned that the items in the previous contract are not subject to change. Is that what's known as an evergreen clause?
No, I didn't say they weren't subject to change. I did not say that.
Okay, so there is no evergreen clause. Anything is open for,
Anything is open
Negotiation.
for discussion.
okay.
Mhm.
Now, you mentioned arbitration over the meet and confer process. I believe there's also a grievance arbitration process, and that's separate and distinct from the interest arbitration process. Is that correct? I mean, it's similar, but it's separate.
So, so there's an arbitration process for discipline. There's not an arbitration process for grievance. So we do have our own internal grievance process for grievance. And so if somebody wanted to bring a grievance because they don't believe the city is implementing something in the MOU the way it was intended to be, or something to that effect, they could bring a grievance to the city. And there are rules in our MOU that outline what the process is for that. And there's no arbitration there.
Okay, so, but if there is discipline involved for a member of that bargaining unit, are all the bargaining units subject to that, or just police and fire?
Just police and fire for the binding arbitration.
Okay. Now, has the city ever used arbitration for contract negotiations?
You know what? Let me back up because I think I answered your question wrong. So you were talking about discipline. All units have the ability to arbitrate discipline. So that is a fact. You got me
So not
confused
just
a little.
police and fire.
Not just police and fire on
everybody.
discipline. Yeah, they all have the ability to take an appeal to an arbitrator.
Okay.
Mhm. What was your next question?
The next question was, has the city ever used interest-based arbitration?
So interest,
Or I shouldn't say the city, have both parties used it, I guess.
interest-based bargaining?
Correct. Over dispute over not being able to reach an agreement on a contract.
Oh, okay. So what you're asking me is, have we ever been in an impasse and had to use
Correct.
that process? So I don't know if we've ever had to use the process. I could probably get that answer back to you, but to my knowledge, I do not have knowledge of any time that we've
Well, I
done
can
it.
tell you have in 2001,
Okay,
but you're not aware of anything since then.
no.
Um, Next question. When you reach agreement and it has been finalized by both parties, is there a time limit for when that contract is posted for the public to see?
So the tentative agreement goes to council as it's a public document when it comes to the council meeting. So it is posted as part of that packet and it becomes public at that time.
Okay, but this last time for the MPOA contract, it was 12 months before it was posted on the city's website. That seems excessive to me. Is there any sort of parameters that are supposed to be adhered to?
So there aren't any rules or parameters. I will tell you that, each time we negotiate with the union, it's its own negotiation. It's kind of unique. I will tell you that, all of the economics and all of the major changes do happen in that tentative agreement. Typically, after the tentative agreement's gone to council, what we work on is language cleanup. And so that's what took a long time for us, was a language cleanup, which we didn't have any substantial, changes. It was really just making sure that everything was appropriate to the operations, and agreeing on, the language cleanup. It did take a long time. It is unusual for it to take that long. I will tell you that, our other units didn't take that long. It typically takes us probably about, I would say at most, probably 2 or 3 months.
Okay. You mentioned that there are 9 comparable agencies.
Yes.
Is that applicable to all of the bargaining units?
So there are some slight differences between safety and non-safety. So the miscellaneous units, which is, all of our non-safety, they have the same 9. But with fire and with police, theirs are a tiny bit different than the rest of the group. And it's because, we had made some changes in past negotiations where we had trouble with losing employees to certain agencies. And so they wanted to have those agencies considered. And so sometimes what happens is, at the beginning of the bargaining process, we may agree to change those a little bit. But with the miscellaneous, it's been the same for a really long time. I would say the last time that the comparables were adjusted at all for MPOA, I think was in 2016. And it's a slight change. It's take one city out, put another one in.
Yeah.
So not a huge change.
Yeah, so the 9 comparables can differ from non-sworn bargaining units to the sworn bargaining unit with MPOA, and there could be a difference between MPOA and MCFFA, correct?
There can be, yes, and there are slight differences. They're not major differences. They're not completely different sets of agencies, but there are a couple of differences, yes.
Okay, and then when you mentioned that the tentative agreements, or the tentative agreement, I should say, goes to an open session of the council.
Mhm.
Prior to that, the council must have some idea what's coming to them in the open
yeah,
session, correct? I mean,
That's
they have,
correct, yes.
they have authorized you to have a tentative agreement, correct?
correct. That is
Okay.
correct.
And then the other question I have, the last question I have is, how is the cost of the agreement determined?
So that's a great question. I would say that, what we do in this, so there's a historical way it's been done. We did it a little bit different this last time when we did negotiations. And so what we do is we try to determine based off of what's being proposed at the table. A lot of times, the cost is considered, right? So we need to know how much that item is going to cost. And we need to make sure that we, look at our budget and ensure that we can afford whatever it is we're agreeing to. And so we include our budget division in that process. And so we work with them. We let them know what's being proposed at the table. They will do some models and try to do some costing for us to let us know how much it costs. And that's typically how the city has done it. However, this last set of negotiations with all of our unions, we used a software program. And so it's a new thing that hasn't been around for a really long time, but there's a company that actually does modeling software where you can upload, and it's much more accurate than a human doing estimates. And so you can actually upload all of your data in there, all of the employees, where they're at in their steps, everything. And then you can put in there what the proposals are, and it will tell us what that cost difference is going to be.
And is there a process whereby the bargaining unit and the city agree on what that cost is?
No. So typically the way it happens is if the union, gives us a proposal, we'll go back and we'll cost it because we need to know what the cost is of it in order to consider it. And then when we come back with our counter proposal, we'll cost that as well. And so we do share some costs. So if they're curious what, X cost, we will share that information with them because that's the information we have to share. And so if for instance, they want to know what a 3% increase would look like for them and how much that would cost, we would provide that information to the union. But we don't agree on what that cost. We don't agree on the cost. We agree on the numbers that are in the 3% or 4% or whatever the case may be.
So what if there's a disagreement between the bargaining unit and the city on what the cost is? Is that an arbitrable issue?
Well, I don't know how they would prove that we were wrong. I mean, so I guess they could disagree on what we say the cost is of something, but we can show the calculations and all of that. So I guess they could
Well, they could do
Challenge
their own
them.
calculations,
They
correct?
could do their own calculations, yes, but a lot of them aren't, that's not their area of expertise. So they could certainly do that. They certainly could challenge it, I suppose. I've not experienced that. Can they arbitrate it? No, I don't think they can arbitrate it unless if we get to an impasse and their reasoning for the impasse is because they don't believe that the cost is the same, I suppose they could do that. It wouldn't be beyond me that could happen. And then an arbitrator would see the numbers and they would probably make that decision for us.
If I understand correctly, the arbiter's decision is final and binding on both parties.
Mhm.
So, depending on whose proposal the arbiter thinks is the most valid or the most reasonable,
Mhm.
that's what's going to be imposed, correct?
It could be likely that, or it could be something in between. Because they don't have to pick one proposal or the other. They could say, we think you should do this, and it could be something in the middle.
So I thought that the arbiter's decision was final.
It is, but they can,
So
They
they
can-
can actually change the numbers or change the issues that are at dispute?
well, so for instance, if the city wants to give 3% and the union wants to 6%, right? The arbitrator could say, a reasonable amount
Right,
would be somewhere in
right.
between.
Right.
So they could certainly do that. Doesn't have
Okay.
to be one or the other proposal.
All right, but if it happens to be a condition or working hours or something like that, the could just decide to do something different than what both parties have proposed?
That's probably too detailed of a question for me to answer. I'm honestly, I'm not an attorney. And so, and I've not experienced that, so I can't speak from experience. So I'm going to decline to answer that question.
Okay. I said that was my final question. I have one more. And this relates to disciplinary arbitration.
Mhm.
Is the process the same? Do you present a panel of three, and then either side can select one of the three? And then if you can't agree on one, then it goes to a 7-panel group of arbiters?
So no, the way the arbitration process works is, the city is responsible to reach out to the state conciliation and mediation board. We request a list of 7 arbiters, and then each party can strike back and forth until we land on an arbiter. If the parties, already know there's an arbiter that they agree upon, they can certainly do that as well. If they don't agree on that list, then it gets kind of a stalemate because the conciliation board will not give you another list. So they'll require you to pick one.
So if there's an employee who is dissatisfied or disagrees with the discipline that's been proposed,
Mhm.
and their bargaining unit decides to take them through arbitration, is it the bargaining unit or is it the employee that initiates the arbitration process?
Yeah, so it can be either or. And so the way the arbitration is, the cost of the arbitration is split. It's between both parties. So the city pays half, the employee pays half. And so it is the employee that elects to do that appeal. And sometimes the unions will support them and help them with the cost of that and support them through the process. So it just depends on what it is, but it can be supported by a union, or it can be just the employee themselves that do it.
And is there a time frame if an employee decides to elect the arbitration process over whatever the disciplinary action was?
Mm.
Is there a certain time frame where the arbitrator has to be selected and the process has to start, the hearing has to start?
Yeah, so unfortunately, the only time limit we have in place is the time limit that they have to actually elect that they want to do an arbitration. And so they do have 30 days after the decision has been made. And so what it is a notice of intent to discipline, a notice of intent to terminate or discipline, or whatever the case may be. Once they've received that notice, they have 30 days to raise their hand and say, I want to arbitrate this. Other than that, that's really the only time limit that we have. Arbitrations can be quick, they can be long. It depends on, the court system and how the arbitrator, once an arbitrator is picked, what their calendar looks like. And so I've, experienced arbitrations that last maybe 1 or 2 years. But typically the choice of an arbitrator doesn't take that long. Usually doesn't take that long.
So when you say it doesn't take that long,
Mhm. There's
you're
no
talking
time
about- You're
limit.
talking about striking the names of the 7 arbiters until you arrive at one.
Correct.
And so can you give me a ballpark idea how long that would be? Maybe, is it 6 months or 3 months or a year or?
Yeah, so again, each situation, its own unique situation. But typically a few months would be probably what we see normally.
Thank you.
You're welcome.
That works. Yeah. What are the 9 jurisdictions that you use for comparison?
Oh, I should have wrote this down before I came down here. I'm gonna go off of memory, so I might not get all 9 right. Yeah.
People on Zoom aren't able to hear you. So,
Okay, my
Mike.
question, now is that word? My question is, what are the 9 jurisdictions that you use for comparison?
Yeah, so I'm gonna do my best to recall most of them. And so we do look at Tracy, we look at Manteca, we look at Stockton, we look at Bakersfield, We look at Livermore. We look at, how many did I just give you? Six. So I should know these by heart. Yeah, Fresno's one of them.
That's,
We don't do Merced. Good guess, though.
Fremont?
We do Fremont for, I believe for fire, but I don't know if we do that one for PD. We don't do Fremont for the miscellaneous group. So there is that little bit. So the ones that I named off are the ones that are like everybody has. And then the other ones are kind of, the one-offs. But I can report back. And so I can absolutely give you all a full list of all three of the different versions of that. Happy to provide that to you.
and when you talked about the different types of bargaining, is there
Mhm.
one that the city and MPD use in terms of either interest-based or traditional? Or
Yeah,
do you
so-
use a mix? Or-
So for MPOA, for the last several bargaining cycles, it's been interest-based bargaining.
Oh, thanks. I have anything else that Ken has not asked. So. Nothing further.
Um, In the scheme of things when in negotiations, regardless what the union is, what percentage is sort of compensation related and what percentage is work environment related?
So when we're discussing items, I would say that, probably more of it is probably more economic based because that's typically what, the unions want to discuss. And so things like wages, incentives like longevity pay, things of that nature. I would say probably, percentage wise, that's hard to say because it really depends on it depends on the union, number one, and then it also depends on what's most important at that point in time. So it fluctuates from negotiation to negotiation. So I'd hate to kind of give it a percentage because it could be different every time.
If something in the course of the contracts in play and there's something that comes up that needs to be addressed, is
Mhm.
there a procedure for both sides to be able to say, hey, we need to adjust something here?
Yeah, absolutely. And so we do meet and confer in between times. And so if there is something that comes up that needs to be addressed, the union can come forward or the city can come forward and approach the other side and say, we have this item that we need to discuss because, whatever reason. We would do the meet and confer process and that would happen in the middle. So depending on, what the item is, it'd be who would be involved. And we would agree to something. Obviously, that would, if it was economic, it would go to the city council. A lot of times the side letters, they're not economic, they're usually operational. So trying to think of a good example. We just had, so I'll give you an example. And so our fire unit, we negotiated with them last year and we changed something in their cash out of their vacation. They used to have in there where it went to a trust instead of to cash to the employee. And you probably all are aware that California law says we have to cash it out, cash. But they have in their MOU an agreement that the employees, when they separate from the city, it will go into this retiree health trust for them. And so they decided they wanted to change that this last go around and, no different cost to us, whether it goes to the employee or the trust. So we didn't have a problem with that. We changed that in the MOU. And then later on, a couple of months after the contract was in place, we recognized that the trust that they had a contract with doesn't allow them to have a choice. It's either all of them do it or none of them do it. And so, so we had to do a side letter because they went out and they pulled their membership to find out what they wanted to do. And again, on the city side, it doesn't really matter. It's no difference to us. And they decided they wanted to revert back to the old language that they had in the MOU to begin with. And so we had to do a side letter for that. So that's, an example of what would happen in between things like that that go on.
Okay, one other question, and this has come up several times in the recent months about the arbitration process being the only way to deal with, and this is just officer dismissal or disciplines
Mhm,
things.
mhm.
And there, can you tell us what other options there are to binding arbitration, and like how well is that accepted, around? Because I'm from my world that I live in is everything's arbitration,
Mhm.
binding arbitration, and all my contracts I send out are all that way. So I don't even know that there's other ideas out there. So I'm curious to see what are the other options?
Yeah, so we're not required by law to have binding arbitration. Public agencies choose binding arbitration because we believe that's the best process whereby to have this, resolved. And the reason is this. So as public employees have a property right, a property interest right to their positions, which is different than, outside private sector. So with that right that comes from the Constitution, they have the right to due process. And so when you have due process, there are lots of different things that we do as part of that due process. But if we were to terminate someone or discipline someone and they disagreed with it, if we didn't have the arbitration process in place, they could they could take us to court in a superior court. And they could sue us there if they wanted to, because they have that property right interest in their position. Now, it behooves the city to do the arbitration process because we're able to have the process of being able to pick an arbitrator, right? We have the ability to try to control that, and we pick someone that has the background and knowledge to be able to make a good decision. And if they take us to a superior court, then you're at the mercy of whatever judge you happen to get, who might know or might not know what the best outcome should be. So it's really a better process for us to do the arbitration, because if not, they do have the ability to do that. There are probably some agencies out there who do advisory arbitration, but again, if it's advisory, they can still take us to court after that because it's not binding. So, right.
Did a list of 7 names, and each party, the employee or their representative and the city, strike a name until there's one left.
That's
So you're
correct.
really not picking that person. That's the only one left, correct?
Well, yes and no. I would agree to you in part. And the reason why is because we still have the ability to strike out the ones we don't like, and we still have some control over who we end up with. So-
And you're starting with a select list.
A select list, yeah.
That's-
And so the way the conciliation and mediation board works is it's a form that you fill out. You let them know if you want somebody, if you want people with a certain kind of background or a certain kind of education, a certain kind of certification. So you can kind of ask for certain things, certain arbitrators that have like experience with, police cases or whatnot. And so when we ask for a list of arbitrators, we can hopefully narrow that down a little bit more by saying, we want people with certain backgrounds. And then they deliver the list of arbitrators that comes up based off of the criteria that we're looking for. I hope that helps.
Any other questions? Okay, seeing none,
I do have one more. Can you describe the actual process? I'm assuming that it's different for interest-based arbitration and disciplinary-based arbitration. And maybe I'm incorrect, but when it's an interest-based issue, are there are there hearings held, or is the arbiter just presented with the proposals from each side? And then the arbiter, analyzes that and comes back with their decision, and they may amend certain things in there that neither side proposed, if I understood you correctly.
Yeah, so I actually explained a couple of different impasse procedures, right? And so the one was the fact-finding procedure. That's for non-public safety, and that
Right.
one's a little bit more informal. The arbitration process, though, is more like a court case. And so you sit in front of an arbitrator, it's kind of like a judge.
So it's a hearing.
It's like a hearing, yep, and you can call witnesses and you can present evidence and both sides get to present what they want to present. They can cross-examine. It's just like a court hearing.
And that's the same for either interest-based or disciplinary-based arbitration.
All arbitrations, yes.
Okay,
Follow
thank
that
you.
process.
Any other questions? Okay, seeing anybody in the audience like to ask a question or speak to this? Thomas? You, come on up. No, come up to the, so we can hear it. Put it on the recording.
Oh, I had three, but I just came up with another one. Did you say that the hearing procedure was not for public safety? Did I hear you just say that right now? Maybe I misunderstood.
No.
You want to just throw out all your questions and then I'll come in and answer them?
Sure.
Try to remember which one.
So that one just came up. I thought you said that well, you were describing the hearing, but you said that was not for public safety based situations. The fact finding does not apply to public safety, meaning police officer arbitration. Okay, so I did hear that right. Okay, so my original three questions. One of the questions was to clarify kind of one of your questions, Mr. Bryant, about how an arbiter can kind of come up with their own solution, doesn't have to choose. But you have, if an arbiter says that, you have the 10 days for the parties to still come together and say, oh, well, neither of us like that, so let's try to negotiate. That's correct, right? Okay. And we were talking about the list and then checking names off the list, but that's for the third arbiter, right? So there's one is picked from each side and then you're picking the third one in that process.
So let me answer that on the microphone. So there's two different processes that I went through when I talked about impasse. And so the fact finding one is where you have that panel. And actually with you're right, I think we have a panel for both. You guys are asking me so many questions, you're gonna get me confused. Yeah, so with the charter process, which is outlined in our charter, so absolutely anybody can go and read this entire process on the charter. But with the charter process, each side gets to pick one, and then both sides have to agree on the third.
And if they don't agree,
Then they're given the list. Yes.
understand that now. My other question was, and I think you might have kind of answered this one, that it's because it's in the charter that the arbitration is binding. So a different city has a different charter that might be different, right? And I think some cities do have it where the arbitration is not necessarily binding. Is that correct?
So I can't speak to other cities. Yeah, that's my phone. Sorry. So I can't speak to what other cities do. I can just only speak to what our city does.
Theoretically.
It's in the
you could have
charter.
a city charter that does it differently.
I imagine so, yeah.
Last question for whoever, I guess, could this be an issue that the independent auditor could look at? We were talking about like comparing it with cities. Is that something that we've thought about, or that's something that the independent auditor could look at? The city charter and say, oh, different cities do it differently. We might have some recommendations. That might not be a question for you. Maybe that's a question for the panel to look into.
Agencies, having the independent auditor look at those and see if all of those have the same sort of language as far as binding arbitration for interest and for disciplinary matters?
Yeah, I guess is it within the purview of the independent auditor to look at this process, compare it to other municipalities and possibly give recommendations to how it could be better, or to say, no, this is, pretty typical and we don't have any recommendations for how to do it differently? Just total curiosity.
Well, we have Mr. Connolly online, and we are kind of a little bit outside of the, I mean, typically questions are asked to the chair, and then the chair will direct staff to answer. So we're kind of just doing a little bit outside of that. But after we're done, it's perfectly acceptable to have Mr. Connolly. I believe, Mr. Chair, if you,
I
if
think
you agree
let's
with that.
wait.
I guess I'm just sharing a thought.
No,
that
no,
could happen.
and I think that's, I mean, he may not be an expert in answering your question, but he does work with several jurisdictions and he can tell us what they do. So we'll get to that once we get to that point.
Thanks, that's it.
Real quick. I know the city of Stockton just put that on their ballot to change it to binding arbitration.
Change it to binding.
Yeah, they
not
want
change
it to
the
become
word.
binding.
They
Yeah,
definitely-
yeah. So that was on their ballot this year. I'm not sure if it passed or not, but it did pass.
I
Yeah.
was just curious. Thanks.
Okay. Anybody else have any questions on this or comments? Okay, Mr. Conley, can you chime in on that question?
So I thank you, and it was a very interesting presentation. I can tell you that most of the agencies that we work with, the system is very familiar to me in terms of the rights to appeal and then the binding arbitration process. So I don't have kind of an encyclopedic, listing of all the places that we work and have worked and the different approaches that they take. But the one that was described in the presentation is certainly very, very familiar, and a lot of agencies and a lot of jurisdictions rely on it.
Yeah, I think, and it's the same, that part of it is the same reason I do it in my contracts. I don't want this thing to go on and on and on forever. And it needs to be decided, and we all need to be, to move on. Otherwise it could, it could just go on forever. So, okay. That was a great presentation. Thank you. And
Stephen,
sure.
so you indicated that that may well be typical, the process, and I guess you meant the binding arbitration process.
Yes,
Or do-
ma'am. That's exactly right. The binding arbitration process that was described for kind of the appellate rights of somebody who wanted to challenge a disciplinary proceeding, that process is one that many, many jurisdictions have adopted for some of the reasons that were described in the presentation.
Do those jurisdictions, if you know, have any time limits as to how or when the arbitration would proceed? I mean, Chairman Hahn talked about the quick resolution aspect of it, at least in the private sector, but it certainly hasn't been quick in the instance that we're all referring to, I think.
Is it ever, are there ever, the only time limit that we talked about was getting the process, to saying I want to do arbitration. And then from there on, it goes its merry way. Is there do other jurisdictions have time limits in their arbitration process? So you have to have a arbitrator determined by this date. You have to start the proceedings by this date. I don't know if that's even legal to do it that way.
Yeah, I would be swimming a little bit out of my depth at that point, Nancy. So I can tell you that an extended process for various reasons, it's something oftentimes that the parties will agree on just for different reasons and hearing schedules and everything else. So it's not outlandishly unusual for something to drag on for months or even years before a resolution. But I don't know a specific answer to your question about whether there are other places that have concrete time limits that are kind of baked into the agreement and everybody has to abide by them.
Thank you.
Okay, I think thank you very much for that. Very, very informative. So the next item is board comments and reports. Policy goal number 8, group, minimize likelihood of death resulting from force. Does anybody have any?
Chairman, whoa, a little too close. I was going to ask a request, I guess. Would it be possible to do the summaries from NACOL first for time? So we have time to kind of hear them out since so many were at NACOL.
Okay,
Not all of us met in the last month on the other.
anybody has any problem with that? Okay.
To do that, take it
That's
out.
the motion. Need a second. Okay, the motion is to move item D to item A. All those in favor, say aye. Aye, opposed? Okay. Now we're going to do the conference report out by the attendees. Who wants to go first?
I didn't go.
You didn't go.
Okay. I'll go first. So I was gonna start a little different, but since we were just done with the topic, there was a session in regards to arbitration at NACOL, which I found very interesting. So I'm just gonna read off some of the notes that I had. For arbitration, the binding versus non-binding, they were talking about, it basically comes down to what's best for your community. And in our instance, through the data that I was given by Lieutenant Kleiber, the city of Modesto actually is like over 90% success rate when it comes to their binding arbitration cases and things like that. So it's very positive because at the NACOL conference, they said typically outcomes, no matter if it's binding or non-binding, are about 50-50. So the fact that, you know, the city of Modesto is over 90%, I thought that was, you know, great, amazing. So when it came down to a couple community members asking to switch back to non-binding and things like that, I felt like it would probably hurt us more than help us in this instance. But the arbitration over time is just standard in all union contracts. And then as well as arbitration, this was something I found interesting because I know when it comes to, say, the officer gets rehired and things like that, there's like back pay that needs to be done. But at NACOL, they talked about the arbitrator can actually negotiate the back pay amount. So that's something that's negotiable and something to keep in mind. And then just for example of different police boards, so in Chicago, their board actually has the power to decide the most serious disciplinary cases, and you know, think of it as a court as well, kind of like the arbitration thing. And then for over 60 years, the discharge cases solely went through the Chicago Police Board, but just recently a court ruled that officers can bypass the police board and go to an arbitrator. And then there was a state trial court that ruled arbitration proceedings shall be public, but the union appealed that and want them to be private proceedings. So there's just a lot of court things that are going on in regards to arbitration.
Is that here or is that in another state?
That was in Chicago. The over 60 years of the police review board being able to determine discharge cases. So that just recently changed. And then let me get back to my notes to get back on track. And that was in regards to the arbitration there. And then in regards to community policing collaboration, they talked about, you know, asking the community, how do they envision their police departments and what are the services and their services and how do they want the police to police their city. And the community feels that more trust is built when they see police is held accountable. In regards to a cultural immersions training for police officers, it can help them navigate diverse communities, build trust, and improve communications. Now, I know that cultural immersion training is a post requirement, But something I want to know is like, do we actually intertwine the city of Modesto with that? Do we take our officers out to throughout the city and say, you know, this is the west side of Modesto, this is, you know, the north side, and actually give them cultural immersion training from our city and our data here instead of just post standards. Um, Another thing I found was interesting for a crisis alternative response was the CARE program out of the city of Eureka here in California. Um, it's a compassionately providing Eureka with community-based, high-quality, easy access mental health and substance abuse mobile crisis service. They do have all kinds of data on their website that I found was very interesting. They gave pretty good examples of how they handled homelessness, from picking them up on off of the streets, providing them with mental health services, substance abuse, things like that, to get them, you know, the actual steps on helping homelessness. Thought that was really interesting. And then another topic that I found very valuable was the public order policing, a modern approach. That was the name of it, the session. And it just pretty much talked about public order policing. So they said like many departments lack policies regarding to public order policing, crowd management, things like that. So there wasn't really any clear standards on how to approach crowds, how to disperse crowds, and wasn't too much training in regards to that. So, for example, when here in the state of Modesto, we had the Modesto March, and how the police dispersed that crowd. Um, I was there, so I kind of saw it firsthand. But they went into what they call dialogue policing, and it's currently being done in Columbus, Ohio, and in Seattle, Washington, with a psychologist out of the UK. I have his contact information. Um, but I thought it would be nice to integrate dialogue policing with our CSO position that the Modesto Police Department has, which is a community service officer. Basically, they go out there if there's any known, you know, protests, marches, things like that that are happening. A dialogue policing where they go out there and they actually tell the community like what is within the law that they can do, how they can protest without escalating anything further. The police were there in the crowd with protesters, but just marked with, you know, high vision vests and things like that, to where um, they just kind of help them get through that protest. I thought that was nice. Um, and then okay, so I do want to touch back on arbitration, guys. Sorry. So one thing that, because they went into very detailed things about how to make it like kind of harder on arbitrators. Three common things that are reasons why things got overturned was like a lack of evidence, procedural deficiencies, proportionality issues, challenges of like impact of authority, it affects the moral and trust, you know, on like the officer side. It kind of helps though with improving the disciplinary process and fostering a culture of accountability. And it just kind of went into topics of like being sure that the work history of that officer that is going through that, like everything is written out. And when it comes to handing over like the personnel file, it's not just filled with the positive work history, like it also has all of their disciplinary actions and things like that that they went through, so that the arbitrator has all the information in front of them. And so it just talks about being proactive to improve the discipline process and coming up with like last chance agreements. And then finally, the police misconduct data. It just talks about coming up with a raw data for public data portals, as opposed to just having a bunch of charts and report tables and dashboards to read off of. Um, and then it talked about why high quality data matters, transparency and community trust, analyzing patterns and trends, understanding workloads, identifying areas for improvement. And Some limitations to some data, though, is that data just might not tell the whole story. So if we're able to get data, and then if we're looking into a specific data piece, like try to get like the reports to go along with it, just so we get the whole story. I know it's a lot. They have so many different sessions there, but if anyone has any further questions, please feel free to reach out to me, and I'll be more than happy to elaborate more on these topics.
Who's next?
I'll add my. Did I do it? Yeah, got it. Just to add and piggyback off of what Nico shared. One of the things I took home was the strengthening community involvement. The sessions were emphasizing the importance of community members in our oversight process. And I think that's something that my ad hoc committee and I have been talking about a lot, that to show community partnership, we need to get community involved because the community is the experts on what they're seeing and what's going on out here in the community. Like tonight, we had 6 people from the community here. We need to quadruple that. We need 60 people. We need to know what our community is saying about our police department, and how are we going to strengthen community involvement. In some jurisdictions, I know there's some states, but there was even for California, I think Oakland has a process going on with, when you're talking about the arbitration. I haven't been on their site yet, but I think they are doing something different. I'll have to look it up. But anyway, getting back to community involvement, we need to be building trust with the community so that they feel that they can come in and share. Also, some jurisdictions have given their oversight committee access to the complaints that have come in so that they know, if the people don't want to talk in person, the complaints that are coming in are being shared with the oversight committee so that they can kind of see and galvanize what is happening in the community and what the community is saying, even if they don't show up at our meetings. Community buy-in is essential to our success as an oversight community. We talked about, there were in some of the sessions, they talked about partnership with our young people. Part of that that I wrote down is like, get with the civic engagement teachers in your local high schools, to begin to talk about that there is an oversight committee for one, and how we can build trust in the community. Mental health was brought up by a beautiful presentation by OIR, and to look at data and what type of resources we need to bring to our community. Although I did put a note to myself that we are doing pretty good with our chat team, and I believe we're embodying MSWs to go out to help us with the mental health crisis here in our community. Another thing is training for our board members on oversight. There is so much more in detail. We'll probably have to have coffee together to really talk about how some oversight committees are operating in various states and even cities, and even here in California. The transparency is super important in an oversight committee, and being able to talk about the different concerns here and how we can do resolutions. Also creating that training, because one day we are not going to be in these seats. Our next board members will need some training, so we need to consider training. There's in New York City, they have a 16-week training for new board members before they take their seat. So that was something that was interesting, because I know it's new to us, we're learning, but I thought we need to start kind of looking at that to develop, because one day somebody else will take our place. What else was there? I think that's pretty much it for me. My quick notes that I wrote down outside of what Nico already shared with you. That's mine. A lot more, but we'll talk about that later.
Thank you. Who's next?
Sure. I wasn't sure if I was going to be giving a report or not on it. I didn't know if it was just the board members. So in addition to what board members Beasley Day and Solorio said, we attended a lot of the same classes, so saw a lot of the same speakers. There was a presentation, I don't think it was mentioned, from a couple of civil rights attorneys from the U.S. Department of Justice who talked about emerging topics for cities and where cities are finding themselves in hot water. And they really spent a lot of time talking about case studies with various cities throughout the United States that they've had investigations with and found noncompliance with law with. And the emerging topics really have a lot to do with homeless response, which is a recurring theme, I think, in a lot of the presentations we saw, and then mental health response, which is also a recurring theme. And one thing that struck me was how the initial 911 intake is where a lot of cities find themselves having problems with their civil rights violations and just not doing a good job of intaking the calls from the beginning, not passing on good information to the officers, that type of thing. So that was something that struck a chord with me, especially being on my side of the table, something, for us to be aware of. And then I did have to kind of chuckle because a lot of the presentations, they were really trying to sell, as has been mentioned, everyone has a different way of doing business, right? We have our way, every city has their different way, and I think a lot of them were trying to sell their way as the best way to do things. And at the risk of being, a negative Nancy or whatever, I was looking at COPA, for example, from Chicago, and they really sold their presentation very well as an ideal way of handling law enforcement oversight, and spend a lot of time talking about their budget, their number of employees. I believe they have 150 paid employees. But then I'm looking at their website, and I was just pulling it up now, and they're taking between 1 and 5 years to finish cases, and which would be illegal in California. We have to finish our cases within a year, but it's very common for them to spend 2, 3, 4, 5 years investigating what are really pretty standard cases. So I thought that was interesting because it was really sold as a great way of doing business. But when I started looking at the website, there was one case where they waited 2 years to interview the officers who, under an allegation, they hadn't written a report, and then questioned why their statement 2 years later didn't match the facts. Well, they didn't have a report to look at. So it's not very surprising. But those are a couple of things. I think some of the conversations, I'm not nearly as social as Board Member Solorio, for example, but you do get a chance to meet people from different areas of the country. Even someone who's a little introverted like me could go and talk to various people and find out how they do things there, the pluses, the minuses, that type of thing. And I think a lot of times you attend conferences like that, those informal conversations are just as valuable as what you get from the speaker. So it was a really interesting experience, really was.
Somebody else might have heard?
Yeah, so thank you. So Simi and I both attended as well, and what it helped me with was just gain a lot of perspective, especially regarding the conversations and the topics that you all are discussing and interacting with the police department. Something that struck me was just I'm a data person and a technological person, and it's the inconsistency of data that a lot of agencies are taking in. And so when you're trying to compare, if you were to compare yourself with another department or another city or something like that, the data is all very, very different that's collected. And so that's something Brian and I were touching base on that a little bit too. So um, every area is very unique. Everybody needs to come up with kind of like what fits. This is just what I was hearing from these departments. And what I thought was super interesting was there were basically municipal police departments that were represented there. I don't know if I remember hearing of any other types of agencies other than just municipal police departments. And that, although there was a lot of representation there, it helped me also understand that not a lot of places have this. And so I think that what we're doing here is although, you know, things similar have been done other places, it's unique at the same time. So that's the takeaway that I had.
Okay.
No, who wants to answer this? Anybody's fine with me. What is your impression as to the attendees? How many of them are governmental agency employees, and how many are board members like us? Would you say? Is it a equal mix, or?
A lot of the attendees were paid board members. And then there was some city employees. I mean, I couldn't really tell who was an officer or not because everyone's dressed just.
They're all undercover, I believe.
But there was
Yeah, I think there were some officers. I would say it was definitely a smaller number though than board members and that type of thing.
Government, like, your CME.
Yeah, governmental employees versus
Yeah, there was both.
basically community volunteers. And then Nico, you said there were some paid board members. So there's obviously a variety of different approaches to this, right?
Yes. Yeah, because like he mentioned about the COPA, which is Chicago's Oversight Police Accountability Board, they take, was it 1%? 1% of Chicago PD's budget. And then they hired 150 employees with that. You know, and 1% of Chicago's budget is pretty big. Yeah.
Was that because they were tasked, they're more independent of the city council, they're tasked, or they were tasked?
Yeah, like they're their
with
own
discipline?
entity.
Yeah.
Yeah.
Simi,
What,
finish your thought and then.
were they the paid board members that you referred to, any idea who appointed them, or were they elected, or how does that? I would imagine
It all
that
kind of differs too.
the agency.
Their city voted them in.
The city being the city council. Or the citizens,
The citizens.
okay.
Mhm.
Simi, what did you learn?
It was a good experience for me as well. I'm more observant in nature, so there was a lot to listen to. I met quite a few people from other entities. I think I could echo a little bit of everyone, but it was a learning experience for me to see both your side as an oversight in various other cities and states, and then also from like as a staff's perspective. So I'd say it was a good experience, and there was a lot of good topics. So I think you guys covered most of it. This is
Okay.
what happens when you go
Yeah,
last.
it's hard to go last, isn't it? Well, thank you. Anybody, go ahead.
Question for Stephen. Stephen, how many of your colleagues attend these sessions? In other words, you know, you're our independent auditor. I'm sure there are many other firms that provide independent auditing services. Any idea what the mix was there?
So the OIR group has been well represented at NACOL over the years. We will send someone, one of my colleagues has been every year for the last 23 years now. I would say I've probably gone to between 15 and 20. And so, yes, the whole idea of people that do our kind of work, that really is kind of the big nerd get together for the whole year. So it's I think a very worthwhile thing. It sounds like people got a lot out of it, and I'm proud to say a couple of three of my colleagues were actually in attendance, and two of them were together on a presentation, the one about mental health with Eureka PD and Burbank PD. And my colleague, Mike Giannacco, whom you've met a couple of times in person, he also worked on a presentation related to prosecution of police officers, criminal prosecution. So we were well represented. It's an organization that we feel like is a great resource in a lot of different ways. And I think it's great for Lieutenant Kleiber to have gone, and we've always encouraged the agencies that we've worked around to go and see the kinds of things that people are talking about and interested in. And I think the police perspective can be very valuable too in terms of the actual presentation. So yes, it's something I very highly recommend, and I anticipate being there myself next year.
Thank you.
Do you have a question?
My question is,
Turn your mic on.
They're doing that. It's actually too seeming being a quieter person and more observant. When you were out of session, who did you find you were talking to? Was it more people that were employees like you? Did you discover you were talking to mostly board members, or was that also very random?
It was definitely random, but I somehow ended up talking to more staff. Just and mainly in California,
Oh,
a
interesting.
couple like in different places, but yeah. I don't know if I can recall too many board member interactions, but more so staff, I'd say.
So for you, that's interesting because I think migration always goes that way to some degree. But in those conversations, as primarily a support staff, did you feel like what we do and how you are engaged with supporting the board is very similar to other entities?
I think one of the things I noticed is like you have to take into perspective the size of the city that they're coming from,
Mm.
and then the statistics of what they're trying to achieve. One of the specific people I remember, they were from Fremont or San Jose. I can't recall which one, but when you look at the magnitude of, I think, the Bay Area versus Central Valley. But overall, like overarching, I think that sort of uh, passion for it was similar. Like everyone's here for the same thing at the end of the day, I think.
Cool.
Overall.
Thank you.
Anyone else?
I have a comment.
Is this, oh, okay, yeah. I want to comment on Board Member Beasley Day's report about strengthening community through involvement. And it's pretty apparent that it's not going to happen here. People are not going to come to us. We have to go to them. I think Trish has given a good example of establishing identity by what she's wearing and things like that. And so I really look forward to when the spring and the summer comes, with us having a tent, a table covering that says who we are, badges, shirts, and that we're out at community events. Police Assistant Chief Valencia and I last night had a very good community engagement presentation at the King Kennedy Center on hate crime, hate speech, and what to do about it if you feel threatened. And so those 50 or 60 people that was there won't come to here. And a lot of times when they come here, it's usually about a problem or whatever. But I thought it was a really good organic, a lot of conversation back and forth. And so I think those are the kind of things that are more impactful that we need to focus on a little bit more.
Great. Okay, let's go back to item B now, is the goal number 8. Is there any update on that?
Hello. Hey everyone. Use of Force Group met a couple last month, went over the new police contract, I believe. And kind of went over some of the verbiage there in the use of force paragraph. We believe that some of the verbiage is just unclear due to words such as should and shall. Like we truly believe that things should be more concrete about what is being done currently with certain situations within that contract. And then also, we also talked about some of the things that we would like to have follow-up on, which would be the arbitration process with Officer Lamantia and just where that's at, whether an arbitrator has been selected or just where that's at, period. We also just want to know more about the mental health clinicians that were actually used through the measure, and also through the police department through their budget, and see like what's going on with that as well. And then also there were talks about how we could actually have people take our board a lot more serious. And I truly believe with some of the ideas that were presented today, that could actually happen. And then also, this is my own personal thing. Just wanted to know if there could be a possible recommendation from our board. We don't have to make a decision today. We can definitely talk about it, but also recommending that after a use of force has taken place, could there be a drug test taking place too? And so that's some of the things that we talked about. We're going to be talking a lot more, especially going on into the new year. And that is the report.
Why don't you go ahead and you were going to make a comment about the form that you're working on?
Thank you. Give me a second, but uh, in my spare time, I do a lot of other things. I can't say too much about what those are here. But however, I would say that I know that in our recommendations that we are supposed to have a Know Your Rights Summit. And I took the time to create that actually. And so I'll be passing that out to our board, and I'll be walking around the room and passing it to others. This is one of those things that will be open for discussion. It is not final. I am one person. We're a board of 9. And so we definitely need to make decisions as far as what that looks like. And that's incorporation from citizens that are in this room and some that are on Zoom if you're listening. And also the police department that's in the room, and also us as board members. And so here you go. And as you guys will take a look at this document, it would have like introduction, welcomes, talks about our board, NACOL, Know Your Rights, and also workshops. So I'll be passing that out to everyone in the room.
Okay, and that's something we're going to be discussing and moving forward. And there's other issues that we've been talking about with the letter from the NAACP to talk about that and to get out in the community, because I think you're right. If we just sit around here, we're not going to, I mean, we'll do something, but it won't be really engaging the community with what we need to do. So we need to figure out what Austin's doing and other touch points that we can get out.
And
Yes.
so, all right, Mr. Chairman, since this is not on the agenda for tonight, we can discuss putting this on a future date
Okay,
for discussion.
let's do that. We'll put,
Yes.
Yeah, no, yeah, that's future.
okay.
I was just gonna comment that last month, don't remember the exact date. Pardon me for that. But I attended a meeting at the Loloma, I think it's called the Neighborhood Church. Chief Valencia was there. There was probably at least a couple of dozen community members there. And Chief Valencia asked me to make a brief presentation on how we function, when our meetings are, all of that sort of thing. So I appreciated the opportunity to do that. And I think, anytime the department has any kind of a neighborhood event like that, I don't know that it was the department specifically. I think it was the department and the city. If I recall, they had different representatives there from the city. But I think anytime there's an opportunity for us to attend one of those events, one of us should be there at least and describe what we do and how we do it and when we do it.
Great. Okay, policy goal number 1, improve relations between the community and the department.
I'll just say we have not met. I was really anxious to hear what Latricia was going to say tonight, so I'm fired up for when we do meet now and the next step of this. So nothing new to report. I will echo Ms. Bird over here. Branding and going in community is a needed piece, and the branding is key, what ties us to our work. But I'll also, again, challenge each of us. The day of our board meetings, are we each sharing outwardly that we're coming to these, invite our followers and the people watching us? No reason why we can't be doing that, and build from there. So thank you. That's all I have.
Policy goal number 3, reduce youth arrests, particularly among Latino youth.
Before I give my report, I want to comment on Austin's Know Your Rights Summit. I think that's an excellent idea. And we look forward to working with you and supporting you on that. And along that train too, on November the 18th, which is plenty time away to prepare, there's going to be a community town hall on law enforcement and use of force in the African American community.
That's February.
I'm sorry, of February, yeah,
Yeah.
of 2025. Yeah, sorry. Oh, okay. All right.
Sorry.
Sorry.
We're all awake, and that's
Yeah,
good.
well, that woke everybody up, so that's good. So, you know, a few months from now, and that will give everybody a chance to prepare. We'll be working with I don't like surprise attacks and things like that, so we'll be working with law enforcement to let them know what type of information and things. It'll probably be a panel discussion. Again, we're going to ask the auditors to come and lend some of their expertise to the public. I appreciate Stephen being willing to do a deeper dive into data and different things when he comes in December, because I think that really, we have to remember our title is community, not law enforcement, but community. We're part of everything. And so until we start convincing the community that we're there to represent the community's best interest, I don't think we're fulfilling our duties. So all of these kind of things are really good. And I'm happy to hear what Stephen is saying. Happy to be working with the assistant chief yesterday and those kind of different things. In regards to our topic of reducing youth arrest, particularly among Latino youth, we have Judge Ruben Villalobos, who's more than happy to come and speak to us. And so I'll be talking to the board and Scotty and Simi or whoever on how do we get him on the agenda, on an upcoming agenda. I think he can provide a lot of valuable information, being as though he is a Superior Court judge that works at Juvenile Hall and sees what's going on every day. It'd be interesting to get his perspective on what we need to do. And then again, trying to get an idea of what the city's budget is like, how much is being spent on creating youth activities as opposed to, how much is being spent on law enforcement, especially with a lot of the new measures and things that have passed, Measure 8 and things like that. How much is available to be reinvested back into youth activities and different things that will incentivize them to use their time wisely or differently. And that concludes our report.
Thank you.
I'd like to say something.
Go ahead.
Okay, two things, because I did forget. We would like an update on, are we still going to be trying to do a study on use of force and arrest with different cultures within the city of Modesto? Are we still looking to do a study on that? And then secondly, I would like for the board to be updated about the police officer that's at Mark Twain and seeing how that's looking and seeing if we're going to be going to different schools with the police officer to host at different school sites, and just want to know an update on that and what that's looking like. Yes. Future meetings, doesn't have to be updated today. Nothing has to be updated today, just future meetings.
I personally wouldn't like to see a lot of money spent on investigating things that we already know about use of force and the data and the statistics. I think it is important, though, to know the context and more information about what are what are the reasons behind the initial encounters in the first place. So it is good to know data, but as far as paying an outside agency, a university or something to come in and do a 1 or 2 year study to tell us stuff that we already know, I think that money could be used to invest in the youth.
Right.
And that's why I believe the information that Stephen and the auditors can come up with in pointing all of us in the right direction of what's important to know and what's not. And, what can we do to move forward into changing some of the systemic issues and also, the past 10-year pattern of use of force, especially against one group of people.
I got one last comment. Since it's on the topic of youth, I was curious on what the protocol is for officers or detectives on campus to talk to students. Like how, or are parents notified? How does that work when officers go on campus to talk to students about an investigation and things like that?
That's a future topic.
Yeah, but it's just something to keep in mind for the youth and that topic.
Anyone else? Anybody from the audience have any comments? I didn't talk fast enough, did I, huh?
I'll try to keep it quick. I just wanted to make one comment about hearing about how many folks went to the NACOL conference, including staff and officers. And I just want to point out that's a big deal. Like, I know I've said this multiple times before, but 10 years ago when I was doing advocacy around police accountability and oversight, to tell me today that we had officers and Modesto staff and our oversight board members going, learning about these things, that's exciting and that's a big deal. And I hope everybody realizes how much of a big deal that is. And I just wanted to make sure that everybody thought that that was cool as much as me. A couple of the thoughts that I had, I really like the idea about trainings and learning about other civilian oversight boards that have been doing this a long time and the kinds of processes that they've developed and making sure that you are passing that knowledge down to the next folks that sit on these boards. I really like the idea about having more community interaction, community forums and workshops. I know that there might be issues around the Brown Act about how many people can, be at a meeting, but I think that that's a really good idea, like was mentioned by several of you, of being at events out in the community. I think that that's a really good idea. The Know Your Rights Summit is a great idea. Valley Improvement Projects, in collaboration with the local ACLU chapter, had a Know Your Rights training a
2
month
weeks
ago or so.
Yeah, like 2-3 weeks
We had about a dozen people there. It wasn't as big as it probably could have been, but I can definitely would be down to help with the planning or anything about that with that event. And the last comment too, because I know that, or actually one more part of that, the outreach, I like the branding idea, and it made me think about the Forward Together committee. It wasn't like a logo, but there was kind of design branding on the agendas and the meetings and stuff like that. So I kind of like that idea, making it recognizable as an entity. And then the last thing I was going to say, because I know the issue about the youth arrests, especially with Latino youth, has been an issue that came up during Forward Together and has been an ongoing conversation. I do think that it's important to reach out to Latino member leadership in the community as guest speakers, or to have like panel discussions at maybe some of these events. Judge Villalobos is a good example, but I think there are others, and that representation, needs to be there for a county. I don't know about the city, but I know the county is almost half of Latino population. Even folks that farm workers, folks that might not even speak English, they are part of the community and should be represented in some of these talks. So that's all. I hope I kept that short and sweet. Thank you.
That's good. Thank you.
I want to mention another idea too, is to think about doing presentations in schools.
And then also another idea, depending on city budget, I do believe we might want to think about sending a couple public members to NACO.
Okay,
Community Police Review Board, community should go to.
okay. Thank you, everyone. Meeting's adjourned.
We have one more item here.
Oh,
Number 7.
Item number 7, future agenda items, which I think we're starting to cover, but I was going to kick it off.
yeah. Okay, sorry.
Let me rewind, I'll rewind just a little bit. Scotty Douglas, Deputy City Manager. So under item 7, it says A is TBD. But what I wanted to just mention is that we printed out, and you guys, all of you, the board members, have a copy of what has been covered for 2024. What I would suggest is that, based on some of the feedback that we started tonight, that we place an item on the agenda, Mr. Chair, that's what my recommendation is for the December 19th meeting, so that we can start vetting that and the topics for 2025 and start building that list out as well. We can take some of the notes that we took tonight and we can send that back out to all of you to say, hey, this is what we've heard from all of you tonight. You'll have some time to think about, prior to the next meeting, topics that you might be interested in hearing about this next year. And then also with staff, we can evaluate those things that are possible and the things that we can strive to support the board as well. So that's my recommendation. And like I said, I think that we've got some good notes so far.
Okay.
One thing that our subcommittee talked about was whether MPD, specifically Chief Gillespie or even Assistant Deputy Chief Valencia, would respond to our board's recommendations in the annual report. And it was my understanding that Chief Gillespie does intend to do that in December or January.
Yeah,
So
I'm sorry, I do have a response. I'm sorry, thank you for reminding me. Chief Gillespie advised me today that he does intend to address the recommendations made in the CPRB report at the 12/19
at
meeting.
12/19,
So
thank you.
he's going to address them. 12/19, oh, the date, yeah, December 19th of 2024. 18th? Yeah. Boy.
I just wanted to clarify that
Six-
because it was
And-
said twice.
18th.
could we also put at least a preliminary discussion of the Know Your Rights Summit on the agenda for December as well?
Yes.
That have to be a motion or no?
Well,
No, I don't think so.
I don't know.
I don't think so.
John, does it have to be a motion?
I think staff can work with the
we don't-
chair.
we can do
so-
that.
Okay.
Well, yeah, because along that line, I'm thinking maybe we need to calendar some of these things. We know there's something in February. When should this happen? And, okay, we've got a couple months. We need to plan for something else so we can spread them out over the year and have them to look forward to and get it on our calendars so that and putting ourselves to work to get the agenda going. So I think that'll flesh its way out.
For those things that we just like spitballed a whole bunch of ideas out at you, what was done previously was actually very helpful, was a list emailed to all of us, and we kind of prioritized in survey format. That was helpful, kind of helped us clean that up, prioritize, and then set schedule, and then adding those calendar events that Brad's referring to that are scheduled that we can add to that. Just a thought.
Well, then can we take it a little further? When it comes to the calendar events, can our board create it instead of depending on the city to do it? Can we just create it so then we all kind of know if we have city events or events going on? I know I'm a part of different groups. We have events all the time. And so I truly believe if we just created a calendar with, amongst ourselves, like all the events that we have planned throughout the year, I think we could just build something that we could actually create and give to the public too.
Yeah.
I think I would just maybe look to the attorney in the room to help us know what the best protocol would be.
So referring to different events outside of the scheduled meetings.
Yeah, right. Like, so if we're a part of different organizations, we could have, events like to not break any Brown Act violations, I'm pretty sure we can all send all of our events to the chair or the community outreach subcommittee and they could create it.
Yeah, I think that the Brown Act thing is a secondary thing. I'm talking about scheduling and then if there is an issue of the Brown Act, then who's going to be at this one and who's going to be at that one? Those are separate things. But I think that just getting it, and I agree with you that to get it all calendared through the year, what we're going to do so that we can all be ready to go.
Yeah, you can do that. And it's part of the board's mission is to engage in community outreach. So as long as there's less than a quorum of the members at an event, then it's not an issue. So you can schedule that with the members and see, who's going to be attending.
Yeah.
If it's less than 5, then here.
Yes.
Suggestion, maybe comment. I think if as individual board members, we're going to attend community events, I think it would be helpful if we have a basic script that, so we're all addressing the same issues and telling the public the same thing. In other words, when I was at the event with Chief Valencia, it was kind of a spur of the moment thing, and I got up and basically did the best I could to describe how this functions. But I think it would be good if we had a script to go by so that we're all providing the same information on a consistent basis.
Agreed.
I'd like to see us have some handouts too, a pamphlet that describes who we are, what we do, how you can contact us.
That's part of the branding.
I think that's a great idea.
Yeah, could our improving relations committee do that? Do we have opportunities to do that? So we can get it done.
Yeah.
Thank you.
Okay, now I need to have a vote on whether we can adjourn now, or do we still have something else you want to talk
I
about?
make a motion
Second.
to adjourn.
Okay. All those in favor?
Aye.
Yeah. I was texting Jane a little bit ago. I'm not sure.